Hey folks, This Week in Law starts now with Copy Hype's Terry Hart, Jeff Orduno, Evan Brown, and me. We're going to talk about Hadopi, iPhone 5.0, Law 2.0, and lots more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise, Howell, and Evan Brown. Episode 179, recorded September 14, 2012. Judges of Unspecified Gender. Hey there, this is Denise Howell, and you've tuned in for the latest and greatest on the developments in the world of technology law with This Week in Law, and our esteemed panel this week of Terry Hart out in Pennsylvania of Copy Hype. Hello, Terry.
Hi,
how are you?
Thanks for having me on.
Hyping the Copy Hype this morning.
Yes.
That's great to see you again.
Good to see you too. Thanks.
Also joining us from Rockford, Illinois, the Sugar Law Offices and Law 2.0 is Jeff Orduno. Hello, Jeff.
Hey, Denise. Thanks for having me.
Wonderful to see you. Jeff has been commenting and interacting with us over on Google+, so it's great to actually see you in person and get you on the show.
Thanks.
And Evan out in Chicago. Hello, Evan Brown.
How's it going, Denise Howell? Good to talk with you. I'm glad that Jeff and I can be representing Illinois well today. It's good to, good to have this panel together. Terry, good to talk with you again. Those are some awesome paintings you've got in the background for those, everybody who's watching on video. It looks like some great artwork going on there.
Thank you. I can't take credit for them, though.
Yeah, looking good. Looking good.
You didn't paint them along with some PBS program that instructed you step by step how to do it?
No, unfortunately not. I was out of paint.
All right. Well, if the urge strikes you during the show, just let us know and we'll give you a little break to go over to the easel.
Definitely.
All right. Well, let's start out with some copyright developments because there have been a number of interesting ones lately. Hadopi over in France has been in the news because they have released some data about its operation and enforcement. And Terry, you had a lengthy post on Monday synthesizing some of that data and telling the world basically to calm down about Hadopi because it's not turning out to be as bad as folks thought it would. Can you expand on that for us?
Sure. Well, I pointed to a number of articles and a number of comments that had been made when Hadopi first launched about 20 months ago, and sort of predicting that this would be, very punitive. It would cut a lot of people off of their internet access. And instead, from the numbers that Hadopi has presented in the last week or so, it shows that that's not really the case. They initially identified, I believe it was 3 million IP addresses that were engaged in sort of file sharing or downloading unauthorized works. And from that, they had, of course, this was a graduated response system, so they had a number of strikes, sort of escalating warnings that started out with an email warning and then would go to certified letter until they reached it started out as 3 strikes, but the report noted that there was sort of an unofficial 4th strike in there. So from this 3 million initial IP addresses that were identified, they only ended up sending 14 cases to prosecutors to give punitive measures on repeat infringers. And I believe just in the last day or so, the first of these cases actually went to court. And the gentleman who was identified in this, he didn't lose internet access. He ended up paying a fine, and I forget how much it was in euros. I think it's about $300 in US dollars.
Yeah, I'm pulling that up now. It was 150 euros. His name was Alain Prévost, and or Prévost in French. I'm not sure how you would pronounce it. And he was fined 150 euros. He had some complicating factors coming into play. He claimed not to have downloaded any of the songs, that it was his wife, whom he is divorcing, who was responsible for this. He then told Hadopi to contact his wife about these downloads, since he was not the person who had engaged in them. It was responding to him at an email account that he could no longer receive, so he didn't have notice of exactly how far along the strikes process, I think, things had gone. He ultimately showed up in court without a lawyer. And although he could have been fined up to 1,500 euros and had his web access denied, the judge ultimately ordered a lower fine, halved the fine, in fact, that the prosecution was seeking. So this illustrates a number of things to me, and I'm getting these details from BBC News' coverage of the case in France. Number one, I appreciate you giving us the rundown and percentages on how many people are actually being prosecuted. I think that's illuminating, Terry, and I get your point there that it's not as though these 3 million IP addresses connected with infringement that Hadopi had identified were all suffering some kind of penalty here. The thing that concerns me about these kinds of laws, though, is that they could. It's a selective enforcement problem. It's a selective penalty problem. The due process in this process is minimal. That we finally get the guy into court, and he has various defenses to what went on, and probably should have gone in with a lawyer and defended himself better. But how many people can really do that? So I get where you're going with this, and you've used the term copyright hypochondria, which I think will make our first MCLE passphrase for this episode of This Week in Law, because I like the turn of phrase. But I'm just not there with you. I'm still in a bit of a panic and a tizzy about this kind of law, especially because we're going to get a similar one in the U.S. by year end, or so it is reported. Evan, what are your thoughts?
Well, there's medicine to help you with the anxiety you're feeling, Denise, and so that's maybe a starting point. I think, less figuratively, the real the real kind of way to alleviate concern over something like this is to look at the marketplace, what has actually happened here. And I think that's what Terry's summary of these data does very well, is to show that, yes, we started out with a set of 3 million IP addresses that were associated with infringing content. And even though the power was there to send all 3 million of those people, I guess, to to be sued for infringement. Think about what a circus that would be. It would certainly lock up the system with even trying to go after a smaller subset of those people. Because of this process, there was something that went into place where a very, very, very small number of people are actually having their rights implicated in a way that we need to even start talking about due process. So. There's great power that comes with this. The power is not completely unwarranted because, nobody has really agreed. Stefan Kinsella is the only person I've ever actually heard come out and say that intellectual property should just be abolished altogether. I think most people agree that there is at least some valid basis for enforcement of copyright rights. Maybe it's a very small set of circumstances in which that's the case. But, these are legitimate rights that are being enforced. There's a mechanism in place which, almost 2 years into it now is shown to be about being handled very responsibly because of market forces, with the copyright owners and the other participants in this not overreaching and using that power in a way that the way that it shouldn't be used. The best thing about it is I just love Terry's term. I guess you've coined this, haven't you, Terry? The copyright hypochondria. I mean, that's just such a colorful way of describing this phenomenon among those who are very, how would you characterize it? On the opposite end of the spectrum of strict IP enforcement types. To note any type of change going on with copyright enforcement is symptomatic of a larger, obviously going to be fatal disease. So I think that characterizes it really well. But I'm glad to see, of course, that the market is keeping this in check and that this process hasn't been abused. And I guess finally, the last observation I would want to make is Hadopi, especially when pronounced like that, seems to be about the most un-French word I could possibly think of. So isn't that ironic?
Yeah, I don't know, guys. It just strikes me that it's not that paranoid to be nervous when someone's standing over you with an axe and the only thing preventing them from swinging it is whether they have the strength and resources to do it. I reserve the right to be trepidatious about both Hadopi and the graduated response system that's going to take place in the U.S. here. What do you think, Jeff?
Well, I would probably pull a Kennedy and split the difference between you and Evan on this one. I tend to agree with you, and that was my gut reaction when I first heard about this. I have due process concerns. But after actually seeing Terry's summary of it, I was favorably impressed that the kind of funneling process seems to work. It seems like reasonable lines are being drawn or reasonable steps are being taken to warn people, and that's actually working. So if we think about bringing this here, as long as you get the due process that you'd be entitled to under law at the end of the day, I think this could work. I was actually surprised when I read Terry's summary because I thought, oh boy, I'm not going to like this at all. And ultimately, it's not so bad. It seems like a halfway decent solution, and I'm surprised that I feel that way.
Well, one of the problems I have is brought up in this French gentleman who has to pay the fine for his wife's pirated songs, and that is this sort of strict liability concept that you're responsible for what goes on your connection, whether or not you did it. I mean, he claims that he's just technically incapable of even downloading songs. He's an artiste and just doesn't spend much time on the computer.
Denise,
yes.
I would have a problem with that here. I have a problem with strict liability generally here for the reason you've identified. I mean, fundamentally, if the guy didn't do it, he didn't do it. So, but I think you have to build that into the statute here.
Right. Okay, Terry, any final thoughts since this is your piece that we're unpacking here?
I did just want to point out some of the differences between Hadopi and the copyright alert system that is supposed to be coming in the U.S. within the next couple months if there's no more delays. Where Hadopi is a legal process, the system that has been designed in the U.S. is this voluntary agreement between ISPs and content holders. And the focus in the U.S. system is even less on punitive measures than the French system. It's been described as 6 strikes. There's basically more steps of escalating warnings when repeat infringers are identified under the U.S. system. And after the 5th or 6th step, it's sort of under the control of the ISP, whether they want to take mitigation measures, if they want to take them, and not necessarily terminating internet access. It might just be, responding to a letter or a temporary cap on bandwidth. And I don't believe there's any fines involved in that at all. And this, again, is something that the ISPs have included in their terms of service almost since the beginning. This limitation on using their services for breaking laws, including intellectual property laws. So they're within their rights to do this. And I think the goal here is to create sort of a consistent system, a fair system that does take into considerations the concerns over due process and not cutting people off from the internet based just on accusations. So, if you take the French experience with Hadopi and how, I think it's worked reasonably well so far. I think, and compare it to the copyright alert system, I think you'll see that that is going to be even more fair and even more favorable to consumers, while also, providing a mechanism to sort of enforce intellectual property rights online.
Well, one thing I do think that the graduated response system in the U.S. could do, we'll just have to see how it plays out, is prevent situations like the god-awful ordeal that Jamie Thomas has gone through. Now having her reduced judgment, she has gone through 2 trials, which have resulted in rather large jury verdicts, which the court has knocked down for various reasons. The RIAA appealed those favorable determinations for Jamie Thomas and won recently in the 8th Circuit, which covers Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota in the U.S. here. So the upshot of the 8th Circuit decision is that one of these jury determinations against Jamie Thomas is going to stand. And I don't think that there's any opportunity for yet another retrial here. That she's going to be hit with a judgment for $222,000 for the 24 songs that were at issue in her case. Of course, her legal team has fought tooth and nail through this whole process, so whatever can happen next, I'm sure will, as far as seeking review of the 8th Circuit's determination. But there probably isn't much further this can go. Evan, were you surprised about this?
No. What I am surprised to hear is what you just said, that Arkansas and Minnesota are in the same federal circuit. Isn't that a hoot?
I know, isn't that weird?
Just like, and like Montana and Hawaii are both in the 9th Circuit too, right? Isn't that? So yeah, yes. That's not the point, obviously. I mean, this case, the Jamie Thomas case, I mean, there's no other way to characterize it than as a very unequivocal, sound victory on the part of mass copyright infringement plaintiffs, like what the RIAA has been, and the MPAA, and then BitTorrent plaintiffs like this, where their sole purpose in bringing these kinds of lawsuits is not to really go and become whole based on the infringements that happened in the particular situation, but it's to get a windfall of statutory damages for what are often very, in the larger scheme of things, very minor infringements, a handful of works. In the BitTorrent case, it's usually one work that's being that's here. So with the whole, it's been no secret that for the better part of 10 years, when it's almost 10 years ago that the RIAA started its litigation campaign like this, which it certainly did throttle back about 4 years ago, it's just to go out and extract settlements. It's not, their goal hasn't been to litigate all these cases through to trial. So what we have here in this situation is a validation by the Court of Appeals on the essential question of whether or not these extraordinary, huge statutory damages awards for relatively minor infringements, whether those pass constitutional muster. And the most important question that was answered by this 8th Circuit Jamie Thomas opinion was whether or not the imposition of statutory damages, which were many, 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 many times greater than any kind of actual harm that the record companies could have suffered here, whether or not that was lawful under the due process guarantees that we have under the Constitution. And so at this point, I think the best thing that we can do as commentators and as people who think about these kinds of things and who are concerned about the inequity that's going on here. I mean, that's just certainly how I feel from a personal level. I think that it's just ridiculous that plaintiffs can get statutory damages this much greater than the actual harm they could have served. I think, based on what the 8th Circuit has said here, at this point, we really need to make the revisiting of the statutory damages part of copyright infringement litigation a big, important priority when we're talking about copyright reform. Let me just, summarize real quickly here what particularly what the court was saying. Jamie Thomas was saying that this is a violation of due process because her lawyers tried to argue that what the appropriate analysis was that they should use these guideposts that the Supreme Court has used to determine whether punitive damages are fair. And so, in that type of situation, it's much better to argue that this award was too high, because in that kind of analysis, the court is supposed to look at, how bad, how reprehensible the conduct was, the disparity of the award and the harm, and the difference between what the actual award was and the civil penalties that would be available to them. So under that analysis, Jamie Thomas had a much better argument to make that this was unconstitutional. But the court said that's not even the right analysis to be doing here. What we really need to be looking at is applying this test that came down in a case from 1919 called Williams, and that sets forth the test of whether or not a statutory damages award is going to pass due process muster. Remember, the guidepost test is for punitive damages, which is something that's different than statutory damages, which are actually set forth in the statute. And so the court said that the Williams analysis was the right one, and the essential question is to ask whether the award is so severe and oppressive as to be wholly disproportioned to the offense and obviously unreasonable. So, we could unpack this a lot more. I've been talking enough, but the court, in doing that analysis to find that the statutory damages didn't violate due process here, said some really interesting and I think controversial things about the effects of piracy and about copyright infringement in the digital world that makes it, makes the application of a test that came from 1919 in a situation, the facts of the Williams case had to deal with overcharging railroad passengers for tickets. They charged passengers 66 cents too much. That legal framework is problematic when you try to apply that to the modern question of mass copyright infringement. So there's plenty of things to be said about how the court didn't necessarily get it right, but they were kind of constrained by what the Supreme Court has said and what the statute says.
Right, and I think you've just very nicely summarized why this is an interesting issue. Of course, everyone says when they lose a case, we're going to take this all the way to the Supreme Court. But this is one that could actually interest the Supreme Court in taking a look at it, because it's a large issue that affects a lot of people. It's complicated. It's relying on precedent that is quite old and perhaps needs some reexamination. So, Charlie Nesson and team, get to it. What do you think about this, Jeff?
I would pretty much join with Evan in that his framework for the analysis. And frankly, I would say it's a crazy train due process violation, especially if you look at the, $1.9 million judgment that the one jury came up with. $80,000 a song bears no relationship whatsoever to anything this woman did. I mean, this is absurd. So even I would say the same thing about the 222 that ultimately the Eighth Circuit upheld, or said you're stuck with that. I guess upheld isn't right, because the judge had kicked that out, and the Eighth Circuit said put it back to that. So crazy train.
Yeah, I haven't looked up the stat lately for of the very many cases that the Supreme Court is asked to take, what the percentage is that actually get through. It's something like 1 in 100, or maybe it's even harder to get through than that. Terry, any thoughts on this?
Well, I would kind of have to disagree with Evan and Jeff. I think in hindsight, from a legal perspective, if setting aside the actual amount of damages that these juries awarded against Jamie Thomas, from a legal perspective, I thought the analysis and the conclusions that the Eighth Circuit came to were sound. Their job wasn't to sort of second guess the jury or second guess Congress, where Congress had passed a law stating what the damages were. We could disagree about whether what Congress did was okay, and I would probably have some agreement there too. But as far as their job in making laws, that's their job. And so the court can't come in and say, we don't like the job that Congress did, unless there's a constitutional violation. We can't encroach into their authority there, and we can't encroach into the jury's role in interpreting these laws. So I think, from a purely legal standpoint, they made the right decision here. If it goes up to the Supreme Court, I can't see the Supreme Court reversing the Eighth Circuit. And remember, we also had this other case in the First Circuit with Joel Tenenbaum, the other file sharing case that went to trial. And there, while the First Circuit didn't rule on this question of which standard to use, either the Williams standard or the punitive damages standard, they did strongly suggest that they would come to the same conclusion as the Eighth Circuit did. And then when that case went back down to the district court to analyze it, the district court came to the same decision as the Eighth Circuit did and said, there's a lot of deference here to the statute that Congress passed. There's a lot of deference to the jury, and we won't upset that. And I think that's the right law.
What do you think, Terry, about how I started out this thread that the graduated response system would actually sort of save people like Jamie Thomas by giving them forewarning that something amiss is on their network? She has contended throughout that she was not the responsible party here either. And at least, if you're not the responsible party, it puts you on notice to go around and figure out what's going on that could get you in trouble. That I do think is a good thing, as long as, the penalties are not extreme and fairly enforced.
Yeah, I think you're exactly right. I think these cases, the Jamie Thomas case and the Joel Tenenbaum case, are kind of, copyright enforcement online 1.0. And now with the Eighth Circuit's decision, it's kind of put a bookend on that. And with graduated response coming to the U.S. and already in France and being debated in other countries, this is sort of online copyright enforcement 2.0. And I think it is preferable. I don't think, the RIAA was sort of in a bind when they first started suing infringers. And I would distinguish their campaign with the current crop that has come about in the last 2 years of BitTorrent lawsuits. Those, I'm not comfortable with those, even though, I think copyright holders do have a right to a remedy, but, it seems they've been more interested in getting settlements instead of actually litigating these cases.
Oh, come on.
So hopefully...
You can't, Terry, come on. You can't say that wasn't the objective of the RIAA. The RIAA didn't want to litigate those cases from 2003 to 2008. That was the last thing they wanted to do. They wanted people to write checks for $5,000 and go away.
I think they wanted both. I think they definitely wanted that, Evan, but they wanted these headlines. They wanted people to know, hey, poor Jamie Thomas has some of the best legal representation available in the country, and yet, has 2 jury verdicts against her, and now the Eighth Circuit in our camp as well, says the RIAA. So, all y'all out there thinking about downloading, you've probably heard of this woman. Don't do it. I don't know. So I think they want both things. All right, let's move on. Sticking on our copyright theme, however, this is a pretty interesting story. Twitter's getting sued, mostly sites that host photos or other user submissions, famously YouTube and the various social networks, very promptly act on requests under the DMCA if someone has contended something is infringing, because that protects them from liability. But this particular suit is against Twitter by a fellow in, let's see, is he in Washington State?
I think so. That's where the lawsuit is.
That's right. And he takes pictures of, it looks like tiny figurines with food. So it looks like they're very nice pictures. I guess that's why infringement is a problem. His name is Christopher Buffoli. Buffoli? Sounds like Hadopi.
Maybe not everybody's French.
Yes, maybe not. So he's upset with Twitter because he's asked, apparently his images have been uploaded there a number of times, and he's having some trouble getting them down. So he's sued Twitter here and has accused Twitter of inducing infringement by not responding to these DMCA notices, which is an interesting theory, I suppose. Evan, did you put this in, and do you have further thoughts?
Yeah, I did. There could be something interesting going on here because on the surface, I don't know why Twitter wouldn't comply with a valid DMCA takedown notice. And from what I understand, Bofoli, the guy, the plaintiff here, was, sent a valid DMCA takedown notice. And, Twitter has every incentive to comply with that because, it's afforded an affirmative defense if it did end up getting sued. For the complying with the DMCA takedown notice would afford it with an affirmative defense, which it now apparently does not have because it's chosen to not take the content down upon notice. So, in any event, this is one of the things that people often misunderstand. Just because Twitter did not comply with the DMCA takedown notice, and even assuming it was a valid one for these photos, that doesn't mean that Twitter is automatically liable for infringement. What it means is that it just doesn't have that affirmative defense that I was talking about if it had complied. So the plaintiff in this situation still has to prove some form of liability for copyright infringement. I think a liability for direct infringement, saying Twitter is the one who is committing the infringement here. I don't think the complaint even suggests that that's what he's trying to say. So what we can divine is that the plaintiff is looking for some kind of secondary liability to pin on Twitter, either finding it to be vicariously liable for infringement or contributorily liable for that infringement. And I think either one of those arguments would have some problems. On a vicarious analysis, it's not clear how he could prove that Twitter's getting a direct financial benefit from having these images on there. First of all, nobody pays to use Twitter. That's the easy thing to observe. And then also, there's not going to be any evidence that people are subscribing to Twitter, that Twitter's getting new users because of this infringing content on there. And I think a contributory infringement claim is likewise going to have some problems because, just providing a website without more is not enough to lend this material support to the infringer that the contributory infringement analysis countenances here. So Twitter, could be making some interesting decisions internally as to why they're going to stand their ground on this, if that indeed is what they intend to do. It could be that, we just didn't see this and we hadn't seen this takedown notice. So we forgot to take them down. Sorry, we've taken them down. Can we settle this case? But it could be that they're biased toward the free flow of information. We know that AMAC, Alex McGilvery, his personal perspective on this and the perspective that Twitter by extension takes is to be in favor of the free flow of information. Maybe they're looking for a situation to observe that just like when they get subpoenas for information for people who are accused of crimes, they don't just fold and turn over that information without a fight. Maybe they're taking that issue into a new context here with the DMCA takedown notice. So there very well could be something interesting going on based on Twitter's decision to not comply with these takedown notices pertaining to the plaintiff's content in this situation.
Yeah, I agree. It's really strange. And I don't know if I buy into the fact that they're going to take a stand on this and say, yes, we are allowed to host user-submitted infringing photos. The photo system on Twitter, whereby Twitter hosts photos, is not that old. I'm not sure exactly when they launched it, but it sort of seems to me like maybe it's a year old or so. Because for a long, long time, all you could do on Twitter was link to other photos. Now it enables you to actually upload, and they host them on twitter.com, and that's what's at issue here. So I'm just, curious about what, the internal discussions and philosophy and strategy was when they decided to roll that out. And I'm wondering, if maybe they just haven't quite sorted out what they're doing with their photo hosting yet. Maybe right hand not talking to left hand sufficiently, legal counsel not perhaps having enough control over the rollout of a new feature. It's sort of add a feature, gain a few lawsuits, perhaps. What do you think, Jeff?
On this one, I would probably split from Evan, and I would, number one, I'm surprised they didn't take them down. Secondly, I get this guy's concern with this. The one thing I don't get about his concern, though, is he's talking about Twitter claiming a license to do this, that, and the other with him. But ultimately, we all, or somebody correct me if I'm wrong, but we would all know that Twitter can't have more than what it actually has. Just because somebody else wrongly put the thing there, if that's what they did, then Twitter can't claim some license by virtue of that. So to me, that's a little bit of a hokey problem. But that aside, frankly, if I'm Twitter, I take the things down. I mean, this seems like this guy is, he's put work into these things. These aren't just kind of one-off or half-baked things. The guy's got work and value in them. So, frankly, if I'm Twitter, I take them down, and I'm with Denise. I don't get really where they're going with this.
That one with the bagel might have only been half-baked. I don't know. There are baked goods in some of
So the coverage that we're looking at to talk about this on the show today is from Ars Technica and John Brodkin over there. And there's another interesting little nugget, not to make another food pun, in there about from Christopher Buffoli describing let's see, he was interviewed in connection with this article, and he says Pinterest, Facebook, Google, and those companies make it very easy to send DMCA takedown, and they respond very quickly. So this is the first time I've seen someone, lauding Pinterest for their crossing of T's and dotting of I's in complying with the DMCA. You can imagine that Pinterest might be kind of quaking in its boots about its liability issues. So it appears to be promptly responding to these kinds of requests. Let's see. Terry, any thoughts on this?
Yeah, I mean, I just wanted to, I agree. It is kind of curious why they wouldn't have taken this down. If I recall, before they had photo hosting, they were taking down tweets when they were receiving DMCA notices. I believe they did something similar to Google where they made the numbers available, and you could see that, they were responding to DMCA notices for tweets and taking them down. So why, this didn't happen with the photos when, this is, it's kind of iffy the extent that a tweet could be infringing or contributing to infringement, but when they're copying photos, that's clearly within the scope of the DMCA. So it is curious, what's going on inside Twitter, but I guess, we'll just have to wait and see how this plays out.
I wonder if anybody's thinking about fair use. These are the people who have linked to these, or who have actually, I guess, what do you call it when you post a photo to Twitter? It's not linking to it.
You upload it. Okay, there's actually an upload button. You know that you're doing that.
So to use the nomenclature of the DMCA, you cause it to be stored on the service at you as the user at your direction. So that's what they're doing here. I mean, a lot of these are in the context. Their Twitter streams are in the promotion of some other thing. So I think it should just at least be a point that we would want to at least think about in our discussion. Not necessarily there's much to parse or unpack on this, but that would be a potential defense that YouTube could think of as because Twitter. You've got to remember one of the things. What did I say?
YouTube.
Yeah. Well, I mean, obviously YouTube defines a lot in this.
Right.
The whole, I kind of glossed over this talking about the secondary infringement analysis. In order for there to be secondary infringement, there has to first be direct infringement. The user has to be infringing here. And without that step one, there ain't no step two. So, that could be that there's something going on here. And if Twitter feels like there's no direct infringement because of that fair use, then that's another leg that they could be standing on in this.
Yeah, I mean, generally what sites do is allow the poster to come in and assert, hey, you never should have pulled this down. This was fair use, and here's why, by filing a DMCA counter notice. But, I mean, I guess it's possible that Twitter has looked at this, done a legal analysis, and said, hey, we think this is fair use, so we're going to not pull them down. it'll be interesting to see where this lawsuit goes. So far, all we have is a complaint filed by the plaintiff, so we don't know what Twitter's position is yet, but we'll keep an eye on it. So Apple goes in completely the opposite direction than that, protecting itself from claims of secondary infringement in its App Store. I guess this has been the case for a long time, and it makes sense to me that Apple does this. I guess it's no surprise, but this is the first news I've really seen about it, and that is that Apple does not allow anything that touches BitTorrent into the iOS store. Torrent Freak writes that for a while they got excited because Apple accidentally, it turns out, approved 2 BitTorrent apps in recent weeks, and you know, that community was getting excited about the fact that perhaps the company had lifted its ban on file sharing applications, but that's not the case. The developer, Craig Donnelly of the Control app for uTorrent, told Torrent Freak that he heard from Apple's people in charge of approvals, and they basically said, whoops, sorry, we didn't mean to approve this, and we're not going to approve this kind of app. Apps of this nature are not allowed in the store. So it seems as though, you know, Apple, even though there are things that can be done with BitTorrent that don't involve infringement at all, clearly there are things that can be done with BitTorrent that do, and Apple has decided to take the conservative tack and protect itself from claims like the one being asserted against Twitter here, that it is inducing infringement or otherwise subjecting itself to secondary liability by saying, no BitTorrent, too dangerous. So, Terry, do you think that was a good call?
Yeah, I do. It's certainly Apple's prerogative to, you know, decide what to allow, what not to allow on their App Store. And I think they did recognize that, like you said, there are legitimate uses for BitTorrent, certainly. But there's also a great deal of infringement that occurs over BitTorrent. And they, you know, probably just decided they didn't want to have to deal with that question. They'll just ban it. And, you know, good for them.
Okay. Evan, what do you think?
We all know what's going on here. This has nothing to do about Apple trying to protect itself from liability for copyright infringement. This has everything to do with Apple protecting its market share with iTunes and its distribution of paid content. So, you know, Apple wouldn't have the least bit of concern about liability for something like this, because this is just, its concern would be mainly if it were accused of being like inducing, like some kind of Grokster style inducement of infringement like this, and so it could very particularly monitor the way that the app was being promoted, so that it's clear it wasn't being promoted with the object of infringement here. So, you know, there's just I'm looking what Beatmaster just said in the IRC here. It says, so Safari needs to be pulled too. You can use it to control the desktop app through the browser. Yeah, great point, Beatmaster. That's right. So that underscores why it doesn't have anything to do with Apple's copyright concern. It has everything to do with protecting their market share when it comes to this.
Oh, interesting observation. I don't know if I agree. I think, you know, Apple doesn't want to put itself in that position of being a target like Grokster. But yeah, of course, there are competitive reasons why this kind of app is probably not what it wants in the App Store. Jeff, what do you think?
I would agree that those are both possible or probable reasons. My thought when I see it is simply that Apple's going to do this stuff. We all know they do this stuff, and eventually consumers can decide whether or not they want to deal with having a device that won't let them have applications that presumably they want. So I guess I don't really judge Apple on it. I say basically let the market judge them. But I wouldn't be shocked if what Evan has identified as the reason may well be the reason, apart from the stated reason.
Okay, well, let's shift gears here for a moment and talk about some issues around privacy. All right, Evan, as we've talked about a lot on the show, you are no longer on the Facebook, but
right.
and we've talked about some of your reasons for that. Some of it has a lot to do with privacy. For those of us who are still there, Cachefly has written about how you might protect your data by noising up what's there around your Facebook page. Can you expand on that for us?
Sure. There's this software developer in Texas named Kevin Ludlow who is working on a project that utilizes what he's calling Bayesian flooding. And stated in the simplest terms, it's flooding this platform, Facebook, and the principle could go to the web at large, or certainly to other social media platforms and environments, where you just flood the data set with so much false information that the algorithms and other technological means by which the provider of this service determines certain predicates about you, like what your preferences are, who your friends are, where you are, what types of things you might want to purchase, so that those efforts are stymied because they're confused. They don't know what's the truth about you and what's so false about you. So, this is an interesting application of technology because, so long as the flooding efforts remain sophisticated enough so that the algorithms that are developed can't keep up with that. I mean, I see some kind of like arms race going on here between the technologies used to flood and confuse the system and the algorithms that are continually becoming more refined to sort out the signal from the noise. Those things are kind of in perpetual tension here. It really does raise some interesting privacy questions because, first of all, there's the fundamental question of what kind of privacy should you expect in the first place, and what's reasonable to kind of engage in self-help like this to protect your privacy. But at least when I go through the analysis and think about this, I mean, it's interesting from a theoretical level, but does it really make all that much sense? Are you, to use a kind of an offhand saying, it's almost like you're cutting off your nose to spite your face here, because if there's going to be so much misinformation about you out there, why are you involved with social media in the first place? If we're going to start from the premise that engaging in social media is so that you can engage with those whom you know, and the value of that to you as the user is the exchange of information that's true about you. So this is interesting at a very general level and a very theoretical level. It's cool that he came up with this idea and it's developing the technology to do this. But would this be of only limited import to social media users? Maybe only this may only be of import to people who don't use social media at all, because they know that if they're not controlling that space, there's going to be information about them there. So they might as well try to make it murky. So interesting technology and some interesting privacy issues that could arise from it. I was interested to see this.
So is this the kind of thing, if you're a person who is paranoid because you can do a Google search on your name and information that's actually true about you comes up, that very notion makes you nervous? Is this the kind of thing that is aimed at that target audience?
Yeah, I think it would. I mean, a lot of reputation management service providers go about their efforts in providing more information about the user on the web that is true, and that would cast the victim of of some bad content, by elevating their profile on sites that have more SEO value and all that stuff. So this would seem to get to the very same effect, but there's that natural consequence of having that much misinformation about you out there, that those who actually may want to find out about you and who you are and what you're all about and what your credentials are and how you can add value to them by engaging in a transaction with them, those efforts would of necessity be done away with because of the misinformation that one is distributing about oneself. So it would cut both ways.
So, Jeff, what do you think the next step in this arms race is? Facebook can't be happy about this. I haven't, done a line-by-line analysis of whether this particular kind of conduct could violate its terms of service, but it strikes me as something that definitely could. Do you think that they would try to take steps against this?
If I were them, I would, and I would do that primarily because this is how they monetize. I mean, I have a problem with this guy, Ludlow, using Facebook as a system, basically weaponizing it, because it sounds like his concern goes beyond Facebook. He's trying to kind of reach all of Google or reach all of commerce, essentially, to muddy up the data that's out there about him in terms of analytics and, you know, buying habits or interests. And, you know, I have a problem with him weaponizing Facebook when the way they make money, and let's be honest, I mean, they're not in this for the sport of it. You know, this is how they make money. This guy is going in, putting false information in, which totally thwarts and defeats the way that they exist, yet he has no problem availing himself of that as a tool and as a weapon. And then, again, I think if this guy really doesn't want information about himself out there or is concerned, because it sounds like that his concern goes beyond himself, it goes to consumers generally, I mean, then how about this? Then don't engage in online commerce or don't do things that trigger that information. Thirdly, I'd say that the guy essentially, this whole thing is a little bit of a sham. I mean, let's think this through. His concern is essentially that hapless consumers are going to get duped into buying stuff because this gives sellers too much information, or sellers too much information. And it's like, well, come on. I mean, really, you know, Ford can put an ad on my page because they know I listen to TWiT, but really that's going to make me buy a Ford. I'm going to run out immediately and buy a Ford because they've gotten inside my head with this. Maybe with kids, but we already have separate protections to deal with that. I don't know. I just... Everybody wants to use the internet. Nobody wants to pay the price. Nobody wants to see the ads. I have a problem with that. Then don't use it or find a different way to pay for it. Go to Mark Zuckerberg and say, hey, Zuckerberg, I want to use Facebook, but I'm going to pay you $20 a year, but don't show me any ads and don't sell any of my data. That would be fair. Gina Trapani actually suggested that on This Week in Google earlier this week. There was some concept about somebody wanting legislation that relates to self-driving cars and what information might be gathered. And, you know, is that going to implicate privacy concerns? And, you know, Gina said, why not just basically pay money rather than having them sell your data? And I think that makes sense. So
they should totally do that. I mean, there's a model for that in so many other services that I'm actually surprised they haven't gone that route, particularly given the flack that Facebook takes over privacy and the not just flack, but lawsuits that it faces. Evan, I think that the market for this kind of a service would be pretty narrow, at least for now. But would that market also include people who, you know, don't want their exes being able to get to the top of search rankings saying nefarious, possibly bad things about them, muddying up the waters that way?
Yeah, that's an interesting way of thinking about it. I mean, that's certainly more defensive, like, you know, trying to keep some kind of reputational harm from happening to you. And that just seems to be one flavor of several among the reasons of why a person would want to do that. And that seems perfectly valid, and the technology would seem to lend itself to that. You know, hearing Jeff talk, I mean, those are great points, and I certainly see the rationality in the disdain for using Facebook as a weapon. It's an interesting choice of words, you know, to use that, but I see where it's going on all this. But I think a larger analysis could be made in examining where the contours of one's personal privacy lie. One of the things that the internet in general and social media even more so has done to us as individuals is taken away this notion that we have a certain amount of privacy by obscurity. You know, for as long as, I mean, I guess for forever, at least in the history of the United States and modern record keeping, modern, you know, being the last couple hundred years, there have been, you know, so there's been a lot of granular detail about each one of us locked away in dusty files in county courthouses. You know, you can go all the way, if you want to do genealogical research and find out about the composition and the demographics of your ancestors living in West Virginia in the 1820s, you can go do that, but you have to dig through, old files in county courthouses. And that's this notion of privacy by obscurity. That's been taken away by social media when, now we are all items in tables and databases that can be searched upon, and more data can be aggregated so very easily, sometimes through automated means. And, we're all cogs in the wheel of big data now. So what this does is kind of reintroduce that principle of privacy by obscurity. And yeah, it may be weaponizing Facebook in one sense, but is there a countervailing personal privacy interest here that should say that, yeah, one certainly does have the right to utilize Facebook to create this amount of obscurity. And, certainly you should be able to put whatever you want on the web in general. That seems like you could almost, it probably wouldn't be a First Amendment issue because it's not the government that's going to try to restrict you. It would be Facebook to try to restrict you. But it certainly is a free speech interest, a norm that we hold dear to us here in the civilized world, that we want to be able to distribute whatever information we want about us within, as long as it's not going to be harmful to someone else in a way that it wouldn't be unconstitutional. I didn't mean to go down that little primrose path. But so shouldn't we be able to say this stuff?
Well, I haven't looked at this product or offering closely enough to know if what I'm going to suggest is even possible. But I'm thinking about ways that this could be legally controversial. Obviously, Facebook wouldn't like it. And we're talking about weaponizing things. I'm wondering if this, suppose you're the opposite person that I was talking about before. You're not the paranoid person who hates to see anything remotely accurate related to you come up in search results. You're the person who wants to be out there, who thinks that that's a good thing, and wants your friends to be able to find you, wants business colleagues to know things about you and be able to sort of use the Google search results about you as a resume. Could this be used in an aggressive way to prevent that person from having an accurate portrayal of themselves on the web by someone who had it in for them? What do you think, Evan?
Yeah, and I think that may be what you were trying to allude to in your question a while ago, right? And I mean, if that's the case, then there's a whole different set of factors we should consider in the legal analysis, because if you're talking about someone else, then there's all kinds of tortious activity that might be going on there that's not going on when the individual is just publishing information about themselves. It might be defamatory. It might be some form of unfair competition if this is going on between businesses. It might be an invasion of privacy. It might be, any of those dignitary torts that that might arise when you're talking about someone else. So I think that the safeguards should already be built into our legal system to keep the abuse from that. And it would seem like the freedom to talk about what you want and say what you want about yourself should be relatively unconstrained as a starting premise. I'm really curious to know what Jeff was wanting to say, because he was wanting to respond to something.
Sorry about that.
No. I just think that this calls into question essentially the Jeff Jarvis privacy questions about what really is public data, what really is private data. Do you get to use essentially false data to muddle legitimate public data? If I don't like what's coming up about me as the #1 item on Google, this top search result, but it happens to be true, do I get to somehow use search engine optimization or some other weaponized Facebook thing to somehow cram that down in the listings? I don't. If it's legitimate public data, I don't know that I favor that. But without getting into whether that's right, wrong, legal, illegal, I think the real questions that what Evan's talking about that come out of this are what really is public data, what really is private data. How do we create and control mechanisms that allow us to, #1, properly understand what somebody, or let's say Facebook, a platform, is going to do with our data? Understand that. And that goes to Doc Cyril's point about, having agreements that aren't adhesive. You just, I truly can read this, like in a few sentences and understand they're going to do this with my data, they're going to do that, and have that everywhere. So how are you going to define what's going to happen with data that we put out there? And then secondly, have the mechanism to control it, or to control the release of that. And again, goes to Cyril's point about like personal web databases, or personal information databases, that I get to say, here's what happens with this data about me. Facebook can have it, but they can't share it. Twitter can have it, and they can share it. Whatever. I think you have to really figure out solutions to those questions rather than this kind of, this is half-baked. this is a half-baked solution to a problem, what this guy perceives as a problem. I'm not convinced it's a problem, but, so I think you got to really look at those issues.
He's a technologist anyway. So
things like this could actually help Doxurls and the VRM movement, I think, because, as things like this get out there, muddying the waters and making data that, everything on the web is questionable to begin with, but you have some comfort in information that you see in search results. If things like this muddy the waters enough, then maybe a personal data vault that is, has some sort of verification involved with it, and that this information is coming from the user themselves, actually gets a shot in the arm from something like this. So interesting to consider it against the backdrop of VRM, vendor relationship management. Terry, what do you think about all this?
Really great discussion so far. I don't really have anything to add, except I did find it kind of funny in the Forbes article that launched this discussion. They were talking about Germany has data protection officials who go around to schools, and I don't know if these are like law enforcement or some private thing, but it just seems kind of curious that they have data protection officials.
Especially in Germany, given its history in the last 100 years.
Yeah.
Well, they're playing catch up, I guess. All right. Well, let us move on and follow up on something that we've talked about a few times on the show, and this is the subpoena to Twitter about the Occupy Wall Street protesters' posts that were once publicly available on Twitter, but now are not. And they've been subpoenaed in New York as part of the case against him. Let's see. I'm not finding the actual protester's name here. Do you know it, Evan? Harris. Yes. All right. So a couple of things have happened this week. First, Twitter was ordered to produce those posts or face a fine. And just today, Twitter actually turned the information over. So at least, Evan, they made the prosecutors go through the whole process of having to subpoena the information and get a court involved to review whether this subpoena was well-founded. And when ordered to do so, Twitter went ahead and complied. I guess, that's just, I'm not surprised about that. Are you? Would you have thought that Twitter might be held in contempt of court or otherwise not in compliance?
I mean, it doesn't surprise me that they did what they did today, turning over the information, because they're a law-abiding company, and they have not violated the law at any point in this process. They've certainly put the government to the test and sort of put the government to its proof, I guess, is the best way of saying it, and have done everything they can to ensure that some form of due process is being undertaken here. But when push comes to shove, and there's the risk of being held in contempt, and the way that was going to happen in all of this, the judge very poetically said, can't put the executives in jail or something like that. But the funny part was, can't put the little bird in jail, the little blue bird.
I can't put Twitter or the little blue bird in jail. So the only way to punish is monetarily.
Right. Notwithstanding Citizens United, I thought you could put Twitter in jail, but they were at risk of having to turn over their financial records so that the judge could figure out what kind of fine to impose, because since they can't put the little blue bird in jail. So, Twitter has done everything it can to the max here to show that it cares about these interests, and as three things really. They care about this user's interest. They care about being law-abiding citizen. I can say that, Citizens United. They're a company. They're a person, right? They've done everything they can, but they've also shown that they're also a company that's out to make money. And when push comes to shove and they're going to be sanctioned and have their financial records made public, they're not going to do that. So we've learned at least those three things about Twitter, and it's win-win for them, I guess.
Yeah, they fought the good fight here. Terry, any thoughts on this?
Well, yeah, setting aside the sort of legal issues here, I'm just really confused about, how this case came up, because if I recall, the this protester was one of the sort of 700 or 800 people who were on the Brooklyn Bridge back in last October, I think, during the Occupy protests. And my brother was actually among those who were arrested. And he was done with the case, 2 months later. They basically, offered everyone arrested, sort of this summary ticket and said, basically, if you're not, arrested or commit any crimes within the next X months, this is wiped clean from your record. So, and he told me most people just kind of took that deal and went their separate ways. So I'm wondering, what the backstory is here, why this guy is still, a year later fighting in court, and also why the prosecutors are so keen on getting, his private Twitter messages or whatever, what they're looking for. But yeah, I agree with the points Evan made. I think Twitter did probably
Reuters,
the only thing it could do. Oh, go ahead.
Reuters offers some explanation, I think, here in its coverage today by Joseph Axe. It says the DA wants the tweets, which are no longer available online, to try to undermine Harris's argument that police officers appeared to lead protesters onto the bridge's roadway only to arrest them for obstructing traffic.
Those pigs.
Yeah. So apparently Harris's tweets would somehow counteract that, or so, they're doing their criminal version of discovery in the case and trying to undermine or take away the credibility from Harris's arguments here. So they must know something or have been told something about what he was tweeting at the time. Jeff, anything else before we move on?
It's a properly issued subpoena. Answer it.
All righty then. Let's see. Let's look next at what's been going on in the world of social web law. All right. So this is something we've talked about before on the show. In Florida, there has been a judicial determination by the Court of Appeals that a judge should have granted a motion to disqualify him or her. I forget if it's a male or female judge here, probably a male, because the judge was friends on Facebook with the prosecutor.
You're saying if they'd been connected on Pinterest, it would have been a female judge. Is that what you're saying?
Yes, I'm disclosing my social media biases and assumptions. Anyway, the prosecutor and the judge were friends. The other side moved to disqualify. The Court of Appeals holds that should have been granted. It wasn't, so it's going back, and I guess the judge will not. If there was a trial, the judge, perhaps the decision would have to be set aside. I'm not sure procedurally what happened here. Jeff, you've been following this more closely. Can you shed some light?
Well, I read the decision, and what we know is that the appellate court applied the standard. I'm going to read from it here real quick. The standard for whether the disqualification should have been granted was if the facts alleged in the motion to disqualify would prompt a reasonably prudent person to fear that he could not get a fair and impartial trial. So they go on to apply essentially the ethics opinion and say, well, essentially this guy has a legitimate concern that he wouldn't get a fair trial. So ultimately they quashed the order denying disqualification of the trial judge and send it back for further proceedings. I don't know. I just picked this up this morning. I don't know what the procedural posture of the case was going into this. But this whole thing is just, it strikes me as silly, I guess.
Why?
Well, two reasons. I mean, what it does is this assumes somehow that what happens in Facebook land is radically and magically more important than what happens in real life. I mean, we all know, we presumably us and 98% of the people listening right now are lawyers. We all know that judges and lawyers are friends. I mean, this is part of life. these people golf together, they fish together, whatever, as long as that comports otherwise with the canons of judicial conduct wherever everybody is. And, frankly, I think it does, because you can't take somebody who came from our ranks, have him become a judge, and then magically he doesn't know anybody. I mean, that's not how life works. But what this does is this says, okay, well, they're Facebook friends, so somehow this creates some appearance of impropriety that otherwise wouldn't exist if these guys, for example, went golfing together or had lunch together or talked about each other's kids or whatever. And really, it's false. It's false in terms of what it purports Facebook can do relative to actual reality. And frankly, it gives Facebook too much importance. I mean, as I think about the people that are friends with me on Facebook, they're, this mix of people that I might talk to, who knows, some of them once a year. Some of them I haven't talked to for years, and I don't interact on them with Facebook. Sure, they're my friends, but they don't have any undue influence over me. It basically says a judge is incapable of being impartial because he's somebody's Facebook friend. But then it says, well, no, that's not what the real standard is. The standard is whether somebody would think that. But the problem with that is that makes perception reality too much at that point. It's just too much.
Right. So in Florida, is there a specific ethics opinion that says that judges and lawyers just should not be connected on social networks?
There is. This goes back to 2009, and I had basically the same thoughts on it when this came down. And I'll quote from that. It's the Judicial Ethics Advisory Committee of the Florida Supreme Court. The issues, they had some of the issues surrounded whether or not judges and their campaigns, if the judges necessarily didn't control the campaign website, whether those could friend people and what the effects of that would be. And mostly those got set to the side as like, okay, that's all okay as long as, the judge isn't controlling it, et cetera, et cetera. The one that results in where we are today is whether a judge may add lawyers who may appear before the judge as friends on a social networking site and permit such lawyers to add the judge as their friend. Answer, no. So this goes back, and basically the Florida Appellate Court's decision takes that part and parcel or in its entirety and says, here you go. We're going to apply that and accept its logic.
It seems like a pretty, based on what Jeff was saying, I agree with you, Jeff, a pretty extreme position to take based on the way that Facebook operates and the realities of social interaction. It seems like you should actually have to come in and say that there is some sort of bias that could be at play in order to disqualify the judge, and that simply having some tangential virtual relationship online, in my mind, shouldn't be able to rise to that standard. What do you think, Terry?
Yeah, I tend to agree with what Jeff was talking about, how this sort of puts undue influence on the perception of, being Facebook friends with each other. And I think from reading the ethics opinion, they sort of distinguish between a site like Facebook where the judge has to approve, someone's friend request, and other websites where, someone might show up as connected with the person, but it's outside of the control of the actual person, and that, that's okay, but where they have to approve their friend, that's not okay. And it seems, kind of odd to make that distinction and to base this on perception, because, how many people, when they're online, are really thinking in terms of like, oh, did this person approve this person as a friend, or is this person showing up automatically? And even on sites like Twitter, the people that you're following, you had to approve them, but then the people that are following you, you didn't have to. So, both these different types of cases are on one website. And, are people really making that distinction? Do they really have the perception, going back to that, these friends are somehow much more strongly connected because they're on Facebook than online. So it is very I think how Jeff put it, it's kind of silly, but you know.
Yeah, absolutely. I do think it's a really murky and confusing area, and that, you know, for lawyers and judges to navigate these waters in the various jurisdictions where they have to is pretty complicated. Evan, why don't you try and give us some best practices here? What do you or would you do if confronted with, here, I'll give you some examples. The judge of unspecified gender who follows your pins on Pinterest, the judge who sends you a Facebook request, and the judge who follows you on Twitter.
Yeah, I mean, certainly the judge, take the easy one, the judge who follows you on Twitter. I mean, it's crazy under any set of circumstances that you would have an obligation, in order to protect your client's interests so that you won't get a case, a judge disqualified at the 11th hour. It would be ridiculous to think that you have to go into your Twitter settings and block that judge who has followed you. I mean, that's just crazy.
As a practical matter, I'm pretty sure you and I have judges who follow us on Twitter. They're not necessarily judges we would ever be appearing in front of, but it's not outside the realm of possibility.
Yeah. Right. I mean, and the first crazy part of that would be to actually go and have an obligation to actually look to see who all your new Twitter followers are. I mean, don't get me wrong. I love all of my followers. I love you all. But, I'm a busy man and I don't have time to go in and do a background check on each and every one of them. So let's just toss that one as like being okay. I mean, with the Pinterest and the Facebook one, I mean, I think those can kind of be evaluated in under largely the same analysis. And the best way I guess I could discuss it is the fact that, I have had more than one judge, practicing in a local jurisdiction here, requests to be to connect on LinkedIn, which, as far as the analysis goes, is applicable to Facebook because the asking to be connected and then the having to consent to be connected aspect is the same on LinkedIn as it is in Facebook. So if that's going to be the relevant point of analysis, then the analysis can be the same. And to be honest with you, when those judges have requested to be my contact on LinkedIn, I have declined it. For one, I didn't know them. I've never appeared in front of them, and I just also saw that it was, and here in Illinois we have elected judges. Jeff would know about this as well. I just saw it was, like quasi-political activity on their part, not trying to impute anything on them that's not there, but they're just very gregarious LinkedIn users, and so I didn't want them to have access to my LinkedIn profile for whatever reason. But also there was a little bit of part in my, conscious mind that said, remember this Florida opinion from 2009, this ethics opinion. And so I decided that was another reason that made me decide to not do that. And I think that's unfortunate, really. I might have decided to not be their contact anyway, whether it be on Facebook, LinkedIn, or Pinterest. The Pinterest is a really funny one because, it's like, oh, what kind of flowers does this judge of unspecified gender like? What does he or she want to wear under the robe? So, I think it's really sad if what we see emerging from this is some kind of per se rule that judges and attorneys should not be connected on social media networks. And there are really two reasons I see how that sadness arose, or that sad state arose. One is this ethics opinion from 2009 is an example of why internet exceptionalism is bad, why we need to develop a special rule for a particular technological context given rise to by the internet. It's never a good idea, unless there are very, very, very extreme situations that warrant it, to craft a regulation or a rule or a law that's geared particularly toward a specific technology. That's one reason why it's bad, because they've come up with this rule that is too broad. And if it's a per se rule, that's unfortunate. The other thing is this underscores why generally in our justice system, we don't like advisory opinions. And by that, I mean this, there's this constitutional requirement for there to be a written opinion issued by a court. There actually has to be a case or a controversy, and the parties actually have to have a dispute that gives them standing to be there. These ethics opinions, first of all, aren't issued well, I guess they are issued under the auspices of a court sometimes, especially in Florida here. But like, here in Illinois, we've got the ARDC, which is, kind of a separate administrative body, eventually under the auspices of the government. But, there's no case or controversy usually. Somebody writes in and say, could you give me an opinion on what this is? And when there's no real incentive for parties to get together and make good arguments, you get decisions that can later be applied in cases to the detriment of what really should be done here. It would be, like I've said a couple times already, it's sad to see, and this is picking up on something Jeff said, it's sad to see judges isolated because of the application of this rule away from the legal community that they serve, away from the society by extension that they serve. And it's just ridiculous to allow them to be a Facebook friend, or to prohibit them from being Facebook friends. And then somebody in IRC was saying, well, then, they should also be prohibited from belonging to the same country club, which is a much more rich context for there to be the appearance of influence that's not right. So that's, it's just not going to be something that is readily settled by broad rules. And, the particular social network shouldn't define whether or not there's something that's gone wrong here.
Yeah, I couldn't agree more. All right, well, let us move on to what has been the biggest technology story of this week, the iPhone 5, and let's consider whether there are any patent implications. So I got to tell you, I tested my theory that every time there's a new fun technological device or service, there are legal implications that we can talk about on the show. And I was happy to see that the iPhone 5 was no exception in a couple of different ways. Over on one of my favorite fun sites, Above the Law, Christopher Danzig has wondered whether Apple's iPhone 5 is a sign of the IP apocalypse. Has a great piece there and points out a couple of IP twists on the release of the iPhone 5. He says, for starters, we have those devious reverse engineering I'll edit, in China, who may have released and patented an iPhone 5 knockoff before the real one was even announced. And he's getting that from Business Week. So then also Samsung, who just got hammered in a very public way, actually manufactures a bunch of components for the iPhone 5 and over here on Above the Law, there's speculation maybe it's out for vengeance, specifically over the LTE wireless technology, because Samsung was reportedly going to take immediate legal action on that front in both Europe and the United States about LTE-enabled products, which the iPhone 5 apparently is. So here we go. New product, new legal issues. Evan, any gloss on this?
It's no new sign of the IP apocalypse. So, I can't point to anything specifically with the release of the iPhone 5 that should think that the state of affairs, the larger picture when it comes to global intellectual property protection and the positions that these companies take and the efforts to undermine that by these Chinese reverse engineers, if that's actually what's going on, aren't they conniving? So this is just one recent, the release of the iPhone 5 is just one other signpost to the larger picture of the problems that we see and the perhaps detrimental economic effects of the application of intellectual property law, particularly patent law, in this scenario. So there's never a bad time to find a reason to reflect on the state of affairs and how it may be able to be improved by patent reform in this situation.
All right. Jeff, any thoughts?
I don't have much to add. I can't even fathom what this is going to uncork. I'll root for Samsung in this one.
Terry, all we know is we're not going to be torrenting on this new device, right?
Yeah, that's true.
All right. Well, there is One other little legal twist that I found over at CNET, Eric Mack has an article. You know how you can get, depending on your carrier, a discount off the list price of new phones when you go to upgrade. I am going to diligently wait until January when I'm eligible for such a discount rather than rush out and get the new iPhone 5. My iPhone 4 is working just fine for now. But in California, it turns out there's a quirk in the tax law where you actually have to charge sales tax on the full price rather than on the discount price. So you can read more about that over at CNET. We'll put that discussion point and all the rest of the stories that we've covered today over on Delicious. There's a public list that's associated with each and every episode of this show that you can check out at delicious.com/thisweekinlaw/179 for this particular show. So I'll just toss it out to you guys. Anyone want to talk about taxing on the full price, or shall we move on to Law 2.0? Going?
That's the only reason we're supposed to think California is kind of screwed up? Whatever.
California is screwed up in any number of ways, but still happy to be here. Okay, so let's move on and talk about Law 2.0, which I'm going to make our second MCLE passphrase for the show. If you're wondering what those passphrases are, lawyers may be listening to this show to get continuing legal education credit in their jurisdictions. Over on our TWiL wiki, we have some instructions about that. Depending on what jurisdiction you're in, we have some forums and guidelines for you for how you can request credit for the show. And one of the things we do is we put these passphrases in so that we can demonstrate to the state bars, should they come asking, that we can show that people listen to the show. So we put them in at random, and before you can get your certificate of attendance that showed that you're eligible for credit, you're going to have to cough up our passphrases so we know you actually listened. So Law 2.0, Jeff, tell us about this and where it is and where it's going.
Well, I think what you're talking about is my kind of informal and recently started blog over at law2.0.org. Number 2 word point, since you can't add another decimal or period in there, 0.org. And the genesis for that actually came out of another enterprise that a partner and I have called Senior Small Business, where we are in the process, and that'll launch actually next month, but we're in the process of taking all of the kind of startup and maintenance parts of a business and trying to streamline that so that a business can, or somebody wants to start a business or a micro entrepreneur can look to that as kind of a single set of resources to get that done. And in the process of that, we realize that there's so much data out in the world, just talking especially to small business people are the bulk of my clients. There's so much data out in the universe. Yeah, we would talk to them about, for example, did you understand how to, I don't know, form a corporation, whatever. They'd say, well, I looked online, and but I, found 8,000 different things, and I wasn't really sure what to do. So what we realized was that there's a business set of issues like that. That's what Senior Small Business deals with. Law 2.0 is the part where my law partner, Mike Scherger, and I kind of came and said, well, there's so much stuff in the law that if you took it and really boiled it down and take the current condition of technology and the current state of affairs, you could make things a lot easier, cheaper, faster for people and for courts and for the systems. So Law 2.0 over the kind of coming weeks and months will deal with issues of access to the court system. And to me, a lot of that relates to cost and to whether or not people are being adequately advised of what a lawsuit will cost and what their net remedy would be at the end of the lawsuit. What am I really going to get out of this? And what's the real expense of doing this? And I think you can create some default rules that help people understand that, or kind of put the burden on us as attorneys. And I'm not usually a fan of regulatory burden, but I think this is one where I see a lot of people out in the world kind of firing up lawsuits, and I see litigants who really don't know what they're getting themselves into, or they think they can sue with a kind of modest case and then get some kind of settlement, and then 4 years later, gee, that didn't work, and they've paid a bunch of money. And it's like, well, that's too bad they weren't better advised in the first place. So there's that access component. And for example, I can't remember the name of the site, but the Canadian website that deals with the small claims cases that kind of walks people through that process, I think is a great example of something that that helps individuals get access to kind of the system by managing them or helping them with cases that otherwise might be cost prohibitive for attorneys to take.
I think that
access
Canadian
cost,
service is My Legal Briefcase. Is that what you're talking about?
Thank you, Evan. And yes, and I Google Plus'd about it and couldn't remember the name right now, so thanks for that. So access cost, net remedy, that all is kind of one piece. Another issue is fairness. Here we go back a lot, actually, to Doc Searles and whether or not, when I click on something because I want to sign up for, Dropbox or whatever, I click on something that, is I don't even want to say Dropbox because I'm about to say something kind of harsh, and and it's not about Dropbox. I don't even want to use an example. But if I go to sign up for some service, and I, like 99% of other Americans, simply take the terms of service pop up and click on it, like, okay, fine. What else are we supposed to do with those? Let's be real about this. We're all going to click on those. Can't that be boiled down? That seems to be. Over the years and over time, we've expanded, and then the lawyers think we need this sentence and that sentence and that sentence and the other sentence. And sure, I'm guilty of it too. But we need to bring this all back around to something that people can readily understand. And I say that about every part of law, everything from a real estate purchase contract right on down to if I'm signing up for Facebook. Tell me what's about to happen. Tell me what you're going to do with anything that affects me. I'll tell you what parts I agree or disagree with. And in fact, in the day of modern technology, to Cyril's point, we may even be able to, I can have, by our privacy settings in Facebook right now, we can kind of have different agreements with Facebook on what's going to happen with different things. We should be able to do that with essentially all services. I agree on these terms, and here are your terms, and okay, line it up. Computers can do that. Do things in plain English, I think, is another fundamental part of that. The other thing I would say is efficiency. We have court systems. Evan may know this as well. As you look around Illinois, and a lot of this comes from kind of Illinois, is my scope. I practice, obviously, in federal court. I practice in Wisconsin. But to be real honest, most of the problems are in Illinois and with Illinois law, to my observation, and I'm guessing they're replicated elsewhere. You have court systems that aren't all uniform. At what we would call the trial court level here, we would call a circuit court level. The district courts that sit above that are the first courts of review, the appellate courts. And then the Supreme Court obviously sits above those. But the circuit courts all have different computer access systems. Very confusing, I think, for lay people to use. Frankly, some of them are confusing to me. In my county, we spent, I think, $8 million to get one that, frankly, is, to my observation, a third as good as the one in the neighboring county that already existed and was cheap. And, so stuff like that is troubling. And I don't see why we can't have a world in which there's kind of an open access court system. If you think of like the federal PACER system, that lets me connect to it and say, hey, I'm the lawyer in this case. Just accept that I'm the lawyer. Here are my credentials. Now let me automatically connect to this database. Not just go and, like we can out of PACER, retrieve documents in the CMECF system. Not go retrieve documents manually. Give me access to that data store. Let me tap into it. And when a new court date is set, there's a platform, essentially, that lawyers, courts could have that automatically connect up. That goes on my calendar by operation of computers rather than, secretary gets the notice from the court and manually calendars it. I mean, because really it's one set of data. We should be able to find a more efficient way to do that. And some of the other efficiency and fairness issues go to essentially trial by motion practice or disposing of cases by motion practice, I think is awfully hard on lay people. A lot of tricks in there. I prefer to see things settled by trial or resolved by trial. So just some concepts like that, and that's probably way more than you and the rest of America wanted to know, but law2.0.org.
I love it, Jeff. It's great. Everything you've put down here is a wonderful thing to aspire to. And as you were talking, I just wanted to make sure you've seen this Terms of Service Did Not Read site. We've talked about it before on the show. I've been referring back to it as they continue to analyze agreements, and they're doing this grading service of what the agreements actually say. I think that they actually go so far as, to grade them too on whether they're easy to understand or not. But they're trying to do the understanding for you and distill it down. So that seems very consistent with what you have going on here too. And go ahead.
I have seen it thanks to your reference to it, and I'll be posting links to things like that. Valorum Law is a law firm in Chicago that has alternative fee billing arrangements. I think that's consistent. So, yeah, lots of fun stuff. Thanks for giving me a chance to mention it.
Cool. Thanks for doing it, and we hope that these imperatives that you've put out will start to be followed around the world, because it will make the law a better place. One thing we know is that GoDaddy had a big outage this week. We don't know if it was a hack. GoDaddy denies that, says it was the result of network issues. Regardless of how it happened, Evan, what should people be thinking about, web services be thinking about when they're considering the inevitable outage that's going to strike them?
Right. One of the good things that lawyers do, one of the funnest parts of the job, and this would be in the way the law has always been, or even in Law 2.0 that we hopefully will evolve into, is help clients identify and evaluate handling the worst case scenario, what could possibly go wrong and what would be the consequences from that. And in that process of developing any kind of service agreement, whether it be a web-based service or, these people have been entering into service agreements for a long time, long before there were even computers. So what developed is this species of animal called the limitation of liability clause. And the language is pretty standard, and you see it in all forms of service agreements, particularly in technology contracts, software agreements, technology service agreements, web hosting agreements like what we see with GoDaddy. And the language is usually written in all caps so that it's conspicuous. And it's that paragraph that's usually, maybe 2/3 of the way through there with like all the disclaimers of warranty that talks about how the provider, shall in no event be liable for anything like indirect, consequential, special, punitive damages, things like that. And so the GoDaddy situation gives us an opportunity to examine why such a provision is so important from the perspective of the service provider, because if we look at all of the things that happened on, what day was that? Was that Tuesday? I think it was Monday, the day that the outage happened. Think of all the page views that were missed, all of the e-commerce transactions that did not happen, all the lost business. I mean, it could be way up into the millions of dollars of things that happened, 2 or 3 layers of causation out because of whatever GoDaddy's issue was. So GoDaddy, of course, having competent legal counsel for all these years and drafting its terms of service, included a limitation of liability clause in there so that if a person, say they have a website and they normally sell 10 widgets per day through their e-commerce function, and when it was down for that day, they missed out on all these sales. They can't go back to GoDaddy and say, because of this, you GoDaddy owe me all the money I should have made for selling those 10 widgets that I didn't sell that one day. So the moral of the story for legal advisors and people who think about these things, and certainly business owners trying to manage their own liability, is to remind ourselves of the critical importance of this very important provision that's at the heart of any sort of commercial services agreement, the limitation of liability clause.
Right. We're sort of getting into the area of Padre SJ's show here this week in Enterprise Tech. But if you have a situation where you really can't have your site go down, then you need to be working on negotiating various uptime guarantees from your providers, which generally aren't the way that these contracts work. Certainly, if you're just going and registering a domain with GoDaddy, you're not going to get any kind of guarantee of reliability or uptime. You're sort of using them as your service at your own risk, and these clauses definitely make that clear. Jeff, just against the backdrop of Web 2.0, as Evan was talking about this, and Evan has a great blog post in more detail on this at internetcases.com. In thinking about our tip of the week here, and the fact that these clauses usually appear in all caps, what happens to me when I'm looking at legalese on a website or elsewhere and I get to the paragraphs that are in all caps, that's when I tune out and don't pay any attention at all. Do you find that to be the case too?
I do find that to be the case. And, you get the boldface, all caps, special font stuff. And, yeah, it's like you just go numb to that. So maybe a little header on it. If we all knew that the header that says, these are the bad things that may or may not happen or that can happen, something like that to make that clear that people would actually read it if it were a sentence instead of, and frankly, I thought Evan did a nice job, like in a sentence of covering a lot of things that, rather than 14 paragraphs of bold caps.
Yes,
I wonder if modern browsers support the HTML blink tag, because that would be a nice way of making it conspicuous. It's like
and scroll. I can blink and like blink and marquee, and that'd be great.
Yeah,
I want all my terms. I want all my terms of service in animated GIFs henceforth.
I think those would actually be more comprehensible to some folks. So we should consider that too.
All right. Well, we have a resource of the week for you that comes to us from Reverb Mike over on Twitter. Thank you so much for putting this in our way. It's Josh Waddles talking about fan art at Comic-Con. There's the complete session on this is over on YouTube. We might be able to play just a little bit of it here for you to give you an idea what goes on. There's Josh.
All the places where everything connects so that you can somehow, out of this miasma of multicolored connectors, come up with an understanding. It's kind of like this is going on in your brain. It's the whole internet. So, copyright law. What is copyright? So, copyright covers the expression in any original work of authorship. It includes the graphic elements.
So Josh is obviously giving a nice broad overview for people particularly concerned with the issue of fan art. So if that is you, head on over to that discussion on YouTube. Again, we'll get it in our discussion points for you, so you don't need to get the link here. His name is Josh Waddles, and I think he'd be a great guest for the show. We'll have to talk to him, Evan.
Yeah, definitely. That later in that piece they were playing, on YouTube right there. I don't know if you watched it far enough into it. It
was an hour long. I didn't watch it.
Did that interview with the guy who was like, dressed in all black, like had his face covered, had a hat on, and was using a voice disguiser because he was like this, pretty prominent animator, done some work for Matt Groening and others, and was still like kind of a bit of a renegade, doing a lot of fan art, fan fiction, visual art kind of stuff. So it was a very one of the more weird types of on-stage interviews when the guy was shielding his anonymity, there in the presence of 100 people, which is kind of a cool thing. Kind of not the typical legal conference type of thing. That's for sure.
No, not at all. All right, guys. Well, we're going to go ahead and wrap this one up. This has been a really fun discussion. Lots of interesting points. Jeff Orduno, great to meet you.
Thanks, Denise. I really appreciate it and enjoyed our day.
All right. Well, we look forward to seeing more of you over on Google+, and folks can follow him on Twitter as well. He is Jeff Orduno there. So good luck with everything, Jeff, and we'll continue to follow your efforts over at Law 2.0.
Thanks.
All right. And Terry, great to have you back on the show.
Thank you, Denise. Thanks for having me back. It's been a pleasure once again.
Terry is Terrence Hart over on the Twitter, and I recommend you run right over there and follow him. Anything else you want to let us know, Terry, before we go ahead and sign off?
No, not really. Just check out CopyHype, my website, copyhype.com. I should have some exciting new projects coming out in the next couple of weeks that I think are really interesting and should be a lot of fun.
Great. We will stay tuned and do check that out. All right, Evan, this has been another fun one. Great to see you as usual.
Well, thanks. Same to you. As usual, really enjoyed our conversation. A lot of stuff, a lot of really interesting issues. So, Terry, great to talk with you again. And Jeff, great to talk with you. I hope we can hook up sometime next time you're in Chicago, or I'm out there in Rockford. It's not far at all.
I'm 2 blocks from your Rockford office for Hinshaw. Come on down the street, or I'll come see you. Thanks, Evan.
Hey, sounds good. Sounds good.
And Evan, you're going to have to, when we're offline not doing the show, find me some sort of bunker that I can put myself into for when the graduated response service goes into effect here in the U.S. so I can be adequately protected.
Right. Put you in some kind of padded room so that you can't hurt yourself from, saying, oh, my God, I'm going to. You're such an infringer, I'm sure, anyway, so they're going to be coming after you.
Yeah, no, I'm paying through the teeth for everything, believe me. But, you know,
Right.
Who knows what goes on your network. Anyway,
Hey,
this has been This has been This Week in Law. We record this show every Friday at 11 o'clock Pacific, 1800 UTC at twit.tv. Come join us live. We love to see you in IRC or otherwise just when we record. If you can't do that, find us on iTunes or in YouTube, on your Roku box, however you like to consume your netcast content. We're going to be there for you. Of course, you can always just go over to our show page at twit.tv/TWiL. We love to hear from you between the shows. Do email us. I'm Denise at twit.tv. Evan is Evan at twit.tv. Let us know what's on your mind, what you've seen, what's interesting, what you have questions about, and we will try and talk about it on the show. And do check out our Facebook and Google Plus pages where we sandbox our topics for the week as well. So with that, we'll sign off. Take care. We'll see you next time.